Welcome to the program. The National Industrial Court in Abuja has adjourned to Friday, September 16th, the suit filed by the federal government challenging the prolonged industrial action by members of the Academic Staff Union of Universities, ASUU. Minister of Labour and Employment, Chris Ngige, who filed the case, is asking the court to order ASUU to resume academic activities. The move follows the inability of both parties to reach an agreement and allow public university students to return to school after a series of meetings. Now, when the matter was called, counsel to the federal government, Tijani Ghazali, told the court that he wanted to file additional evidence, while counsel to ASUU, Femi Falana, urged the court to step down the matter to enable both counsel to file their papers and then return at a later date. Meanwhile, an application by the Social and Economic Rights and Accountability Project, SERAP, to join the suit was not granted.
Not the first time government had adopted this rather dilatory tactics, which have a way of prolonging strikes. We were here last year when you had the resident doctor strike. It was the same approach. They said they won't be paid. At the end of the day, government had to pay them. When the government says there's no money, but you know there's money in the country. But it's a question of priority. Has the government given attention to education? And we must run a country where agreements are observed by governments under the rule of law.
One of their major issues is the issue of payment through either IPPIS or UTAS. Yeah. We are saying that that cannot be dictated to government. We reserve the right to pay the way we believe is most appropriate in the circumstance.
The action of the federal government is totally condemnable in trying to abandon the negotiations that commenced already and not allowing that process to go through.
Well, for more on this, we have joining us legal practitioner Dr. Ayodele Gatta, and we will be having an arbitrator, mediator, and advocate for homegrown administration and development of arbitration later on joining us. And her name is Shola Oshodi-John. She's an expert in dispute resolution, but we'll just come to Dr. Gatta at the moment. Thank you so much for finding some time to join us. Now, talk to us about why the federal government had to take this last resort, to head to the court, the National Industrial Court, to try to get the striking university lecturers back to the classroom, according to it, while the negotiations are ongoing.
Yes. Thank you very much. The problem of incessant strikes in our tertiary institutions in Nigeria has become somewhat of an albatross. It's a recurring problem. For decades now, hardly a year passes without there being one strike or the other. And it doesn't tell well about the state of affairs in our nation. The fact remains that a nation that toys with its educational system toys with virtually every area of human endeavor. And at the end of the day, it has a deleterious effect on our socio-economic and political well-being. That is where we are today. The federal government going to the National Industrial Court is a good development. It shows that this country is still ruled by rule of law, but we can say it is belated. While on their own part, they might say because of the prolonged negotiations, back and forth discussions, and that as at now, because no headway has been made, the last resort should be to the instrumentality of the law. And that is exactly what they have done, pursuant to the provisions of Section 17 of the Trade Disputes Act. Thank you.
Now, isn't it a case of someone who is actually being accused rushing to, seek justice when he or she should be the person, providing solutions? Because, ASUU is accusing the federal government of not respecting the agreement reached. So why does it look like the federal government is trying to untwist ASUU members into this issue, when indeed it's very, very clear that there was an agreement reached with university lecturers, and it's the federal government that has failed to act?
Yes, in this part of the world, like in several parts of the developing world, the sanctity of the law our adherence to rules, regulations, and laws, you understand, still remains at a very low ebb. That is why most times you find that people resort to self-help as a result of the slow pace of justice. Like you said, it's like the accuser or somebody who ought to find a solution to a problem rushing to go to the courts. But the fact remains that no matter how you look at it, the court remains still the best form and a civilized manner, a civilized instrument. We look at the law as an instrument of social development. So the court still remains the best avenue for the federal government to ventilate its grievances. Now we are talking about two sides, two opposing sides, and you see in a negotiation or bargaining, in bargains, you find that each side tries to get something which will be beneficial to him or her. Like the federal government, what they are saying is that the demands of ASUU is too humongous for them to meet, that there are several other sectors which are all crying for attention, which is a fact. But you find that for ASUU, for too long, you know, as an undergraduate in the 80s, we got used to this mantra that my take-home pay cannot take me home. You understand?
Yeah.
It's laughable, but when you look at the condition of members of the ivory tower, it's less than enviable. So by going to the courts to seek redress, it is good. And the beauty of it all is that the National Industrial Court is a court that is really good at mediating in industrial disputes. Pursuant to the third alteration, that is section 254C of the third alteration to the 1999 Constitution,
which empowered it,
which empowers the court, yes, to mediate in, you know, finding solutions to industrial disputes, collective bargaining, child abuse, workplaces, promotion of ethics in places of work, and others.
Yeah, but the federal government's viewpoint is that they should go back to the classrooms while some of these discussions are ongoing. And of course, you would have heard that issue of whether they should continue working. I mean, after the federal government has met all other conditions, yes, they can go back to the classroom without the monies or their salaries paid. That's for the time that they were on strike. I mean, as a legal practitioner, would like to hear your own view on that perspective. Can striking lecturers still be demanding for salaries when they didn't work at that period that they went on strike? Because by deciding to go on strike, you have acceded to the fact that it may go the other way. You may be paid, you may not be paid.
Thank you very much. You know, when you look at the law holistically, laws are predicated on morality. Like they will tell you in the layman's language, a hungry man is an angry man. I'm not saying ASUU members are hungry, but we see a concatenation, a series of agreements in time past to which they faithfully appended their signatures to, giving legal backing to whatever agreement might have been reached on both sides. And the grounds of ASUU is to the effect that serially the government keeps violating those agreements or observing them more in the breach. Now, what the federal government is trying to seek out at the National Industrial Court, one of the remedies is this, that there should be cessation of the strike. The lecturers should go back to work while negotiations are still ongoing. And this position is predicated on Section 18 of the Trade Disputes Act, which provides that once a matter is before the courts, strike and as an instrument of a protest should be seized. Workers should go back to work while conciliation.
That means the status quo should be maintained.
No, if you say the status quo be maintained, it depends on what
on the interpretation. I mean, status quo before the strike or during the strike.
Thank you. When you talk about status quo is something, though it is something which is well known in our jurisprudence, but the fact remains that when you are giving interpretation to the meaning of the word status quo, the interpretation you will give to it might be different from mine. Because what we are looking at is what is beneficial to me and what is beneficial to you. If we are talking about the status quo is what exists as of today when the industrial court was approached for redress, and which means what? That the strike should continue. But when Section 18 provides that they should go back to work, there should be cessation of trade dispute hostilities, go back to work while conciliation continues, while both parties continue to judge over the issues in controversy.
Okay. Now, ASUU members are accusing the government of playing games with them, because we've seen this same situation playing out with the resident doctors, where the federal government said it wasn't going to pay resident doctors who were on strike during that period, and their salaries were stopped. But eventually, their salaries were paid when they came. And then, of course, other institutions, workers that have gone on strike, and then, you know, this kind of things have happened. What does it look like the federal government, when it comes to ASUU, it's a different ball game? And from the perspective of the federal government, do you think that ASUU too is holding the nation to ransom by keeping university students at home?
Well, like they will say, he who wears the shoes knows where the pinches, you understand? The fact is that for too long, while some people might look at it that ASUU is holding the nation to ransom, for them, they are not holding the nation to ransom, because they will always tell you that what they are fighting for is based on principles.
Isn't there an end to fighting for that particular thing? When in a situation whereby you are having random strikes every 9 months or 1 year or 2 years or 3 years, students are also saying that their rights are being deprived as people who ought to have good education, that the lecturers too are not being fair to them.
Yes. Thank you very much. The fact remains that for ASUU, they view this impasse between them and the federal government as a case of insincerity on the part of the government. They view it so because they feel that there have been a series of agreements executed in time past between both sides, but that the federal government has not been faithful in carrying it out, in executing such agreements. You made reference to the Nigerian Medical Association and other professional associations which went on strike at one time or the other. But we find that even those associations, they've not reached a conclusion. Their own strike too is a recurring decimal. Who knows, as we are getting out of ASUU strike, NMA might be going on strike again.
Yeah,
because
most times the suspension
the suspension is like an armistice in time of war. You understand? So for them, what they are asking for is utmost good faith on the part of the government. And as a refrain, I just read that the Minister of Education said, next time, the federal government will not put hand to paper on agreements, the purport and intent which they do not understand. What does that tell you about everything? It shows that, like, with due apologies, it's like saying we are not a serious nation.
Yeah, but I mean, the focus actually of that statement was on the fact that government will no longer enter into a negotiation that on terms and conditions that it cannot fulfill.
They cannot fulfill. Yes, definitely.
So isn't the government right to actually say that, look, you're asking for me to pay 2.5 trillion and all of that? I can't. I mean, I can only afford maybe 1 trillion. And even the 1 trillion, I will have to break it down. I mean, you know, the agreement reached with Jonathan's government. it was that, okay, we are going to, within the space of so amount, break this so amount and pay. And then, of course, the nation's revenues kept dwindling. So what do you do within that circumstance?
Yes, it's true. You see, but if you enter into an agreement, you know, as lawyers, the first thing, if you are guiding your client through the process of executing an agreement, you look at everything, both literally and legally. You understand? You look at agreements which you feel are unconscionable. You look at provisions which you feel are unconscionable. You look at provisions in such agreements which you feel are not within your own capacity to fulfill. And there is something about agreements. Agreements, oftentimes, it depends on the parties. There is always room for back and forth movement. Agreements have to do with, you know, give and take.
And this is can there be a room for a force majeure? If, for example, the nation is expecting monies from cruises and all of that, and all of a sudden there's a global COVID-19 virus breakout, which eventually stops the government from getting more revenues than is expected. Isn't there supposed to be like a force majeure within this instance whereby the government can call for a cessation on the implementation of the agreement? Because, I mean, something that's within this, that's beyond its powers has happened to it.
Yes, thank you. You see, in agreements, most times, like a breach of agreement, breach of contracts, you understand? One vitiating factor in the execution of agreements is force majeure, which ordinarily translates to an act of God. You see, when there is a supervening intervention by forces which is beyond human comprehension, you understand? Most times you find that the party angling for some benefits, he will understand too. You understand? Take, for example, we saw what the pandemic, the COVID-19, how it affected all areas of human endeavor, both private and public. We saw revenues dwindling and what have you. If, for example, there is an intervention by an act of God, you understand? Definitely, ASUU members, we all live in the same community. I don't think they will be so unreasonable as to still insist on their rights.
Well, that's what the government thinks they are doing at this instance.
You understand? That is my own personal opinion, but I don't think they will be unreasonable as to continue to insist on their own rights.
Okay, I'll ask you to hold on there and let's go on a short break. And when we come back, we will be joined by a chartered arbitrator who will help us understand some of these issues. Stay with us. Welcome back from the break, and we're still discussing the federal government's suit filed against university lecturers in Nigeria, which has now been shifted till September 16th. And I still have with me in the studio to discuss the legality of the case, and we have been discussing all other issues too, legally, Dr. Ayodele Gatta. And of course, we have an arbitrator, mediator, and advocate for homegrown administration and development, arbitration and alternative dispute practice in Nigeria and Africa, Shola Oshodi-John, joining us at the moment. Thank you so much, Shola, for joining us. Let's take a look at this issue from the perspective of being an arbitrator. Why is it difficult for the federal government and ASUU to reach this resolution outside, and they have to approach the court, and it looks like there are no mediators around, including elder statesmen, that could actually bring these two parties to the table so that the education sector doesn't suffer?
Okay, thank you very much for having me in Arise TV. First of all, I would like to say that bringing in the issue of arbitration and alternative dispute resolution to resolving ASUU and the federal government dispute at this moment is something that my patron and former president of the Nigerian Institute of Arbitrators, Afe Babala, founder of Afe Babala University, had initially in May suggested that both parties should involve the Nigerian Institute of Arbitrators to use arbitration to resolve the dispute. So elder statesman like Ariafe Babalola has actually, suggested this in May of this year. I think that probably the parties had they didn't avert their mind to it. But having said that, there is actually a laid down procedure for resolving disputes that has to do with the university system and a federal government, and that is the Trade Dispute Act, as well as the Trade Dispute Act actually came up with different mechanisms by which you can resolve the dispute, from negotiation, which we've seen that has failed, to arbitration using the industrial arbitration panel, and if they're not able to resolve the dispute, they will now proceed to the National Industrial Court of Nigeria. I believe that they have probably, tried to use some of these mechanisms to resolve the dispute before they got to the National Industrial Court of Nigeria. But I think that one of the main issues that really is affecting both parties' ability to resolve the dispute has to do with the issue of trust. Because if you look at the Trade Dispute Act, if you look at the various mechanisms that has been set in place, a major principal party that has controls what happens in this process is the Minister of Education, is the minister. So I think that also would have affected ASUU's ability to believe in the process that has been put in place right now. But having said that, I believe that as an arbitrator and mediator, that really mediation and arbitration can be used to resolve this dispute. But the issue here is who is going to be the arbiter or the mediator in this instance? Because it is clear that because of the lack of trust and confidence in the process that is already existing by law, there is a need for the federal government and the Academic Staff Union of Nigerian universities to, come together and agree to appoint an independent body to help in the resolution of this dispute or its settlement. Because going to the National Arbitration Court, to National Industrial Court,
yeah. Go ahead.
Is good, but will it achieve the purpose? Because we all know that the schools have been shut down for over 6 months, and that is really a long time for students to be out of school. We all know the effect of that on the students and the parents. And so using mediation as the first approach, and then ending with arbitration is mechanisms that the parties will need to agree to. And if there's an agreement to that effect, then an independent body, I believe, should be approached, recommended to help these parties, because I do not see how ASUU, at the end of the day, will be comfortable with the decision of the National Industrial Court, because, based on the Act, the National Industrial Court is set up by the federal government of Nigeria. And the federal government of Nigeria is a party in this dispute.
Okay.
So you're sure that ASUU may not be happy or believe that they will get, justice in this regard.
Okay. So the federal government, sorry if I may interject here, the federal government is insisting that this dispute can continue being resolved while the lecturers go back to the classrooms, so as not to deprive the students of their right to education, because it's getting out of hand. I mean, getting close to 7 months now. Within your terms of arbitration, can this be possible if a dispute is being looked into between two parties? Can one party be asked to continue the job he or she was doing while the issues are being resolved quietly?
Well, it is possible depending on the terms of the agreement, between the parties. It is not something that a party can unilaterally decide on right now, because if you look at the 7 months that has elapsed, communication, the ability for the parties to really come to the table together to agree on this thing has broken down. So my view is that because of where they are, there is a need for the issues to be isolated. You need to look at what are the issues that ASUU is asking for and what's the position of the federal government of Nigeria. So is there the possibility that if ASUU decides, okay, let's go back to school, why we are in arbitration or we are in mediation, will the federal government agree to whatever settlement is arrived at using this process? Number one. Then secondly, who is going to serve? Who are the people that are going to serve as mediators and arbitrators? To gain the trust and confidence of ASUU to say, yes, we believe that with this system in place, this dispute resolution mechanism in place, the federal government will definitely abide by the terms of settlements at the end of the day, eventually when they're sworn by this body. So there are some other issues that needs to be looked at.
All right.
For ASUU to really say, okay, you know what, we believe in this system that is in place right now.
All right. So let me bring Dr. Gatta in. In this instance, we've seen the federal government always, based on precedents, pushing this kind of narrative, asking ASUU members to go back to the classrooms while negotiations are ongoing. And just when the lecturers go back to the classroom, before you know, they just keep dilly-dallying on the issue. And is it an issue of a breach of trust over the years? Go ahead, Dr. Gatta.
Thank you very much. Like Shola said, the problem between ASUU and the federal government hinges on one fact: lack of trust and suspicion from both sides. So what we are seeing is that whatever agreement they append their signatures to, it should be executed with sincerity on the part of both parties, and more especially on the side of the federal government. Sincerity, utmost good faith. Utmost good faith. You see, it won't be good if either of the parties is found to approbate and reprobate at the same time. We've seen a lot of agreements. So many committees have been set up, from the Wale Babalakin SAN committee of 2009, and the latter one of Professor Jubril Bunzali of 2020, up to the latest, that of Emeritus Professor Nimi Briggs. What ASUU is still saying, it has become like a refrain, is that there is no good faith on the part of the federal government. And for them, what they've embarked on is like a make or mar protest via the instrumentality of their own strike action. They feel that if they go back to work, the federal government will still renege based on serial antecedents with respect to agreements signed before now. But the fact remains that, like I said earlier, the provisions of Section 18 of the Trade Disputes Act, that is what the federal government is using as its own launchpad in asking ASUU members to go back to work while negotiations continue. And I would I've been very circumspect in making some comments
very quickly
with respect to most of these issues, because the matter is sub judice, and as a legal practitioner, I'm bound by the provisions of the law.
Yeah, that's why we've been trying to play around the issues. Well, as we try to round off this conversation, Shola, tell us what needs to be done to engender trust at the moment, as it looks like the university lecturers don't want to ever trust the federal government again. And the federal government is insisting that if you didn't work at a particular point, there's no how you can get salaries for that point. Yes, we may be able to meet your expectations on other issues, but on the issues of paying you salaries while you were on strike, you should have known before embarking on strike that once you're on strike, you won't earn any pay.
Okay, let me respond to the question of how do they build trust and what the way forward. I will suggest the federal government wants this dispute to be resolved. Just like if ASUU as well wants it to be resolved, the way out that I think would achieve this resolution speedily and effectively will be to invite an independent body. So there'll be to invite an independent body that has the ability, like my institute, the Nigerian Institute of Chartered Arbitrators, or other institutes that the federal government may decide to appoint, or even notable arbitrators and mediators. You can select them from all over the country and say, this is what we want you to do. We want to resolve this dispute. The federal government is serious, ASUU is serious. So this body, or these 3 arbitrators, we have given you the power to help us resolve the dispute at hand. And we also will sign, they need to sign, there should be an undertaking to say we both agree to whatever award or settlement agreement will be arrived at by this body of arbitrators or mediators, whichever they decide to start with.
All right.
Like I said earlier, you can start with mediation and then end up in arbitration. Okay. Why am I suggesting this?
Very quickly,
because within 2 weeks, this dispute can be resolved if arbitration or mediation is chosen by the federal government and ASUU, as well as an agreement is reached that an independent body or independent arbitrators and mediators are going to be used.
All right.
I don't think that ASUU is going to really believe in whatever is going to come up from the National Industrial Court or the Industrial Arbitration Panel, because the federal government has some powers over these institutions that I just mentioned.
We must thank you so much. Shola Oshodi-John is the CEO and Registrar of the Nigerian Institute of Chartered Arbitrators, and of course she's an expert on alternative dispute resolution practice in Nigeria. We must thank you so much. And of course, one of your former presidents, like you said, Dr. Afe Babalola, for providing that suggestion, because it has shown that as an elder statesman, he still has an interest in the country's development. We must thank you immensely for providing that sort of window for both parties to talk about and consider. Well, we must also thank you, Dr. Ayodele Gatta, for helping us to understand these issues. He's a legal practitioner with several years of experience, including in the academia. We must thank you so much for joining us on the program.